Major breaking news out of the Commonwealth of Pennsylvania. The Pennsylvania Supreme Court has issued a major ruling in favor of the Second Amendment, specifically in a challenge to Pennsylvania state's preemption laws that prevents cities such as Philadelphia and Pittsburgh, for example, to enact their own anti-gun legislation. The Pennsylvania Supreme Court says, no go, verboten, not allowed, and upheld Pennsylvania's preemption statute. This decision will not only help you defend our rights in the state of Pennsylvania, but all around the country. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the new law review article in the Georgetown Journal of Law and Public Policy entitled Dangerous but Not Unusual, Mistakes Commonly Made by the Lower Courts in Post-Bruin Lawsuits. It's totally free. Check out a link to it in the description of this video. About 60 some odd pages long, something like that. Walks you through in great detail how to do Second Amendment analysis. So if you want to geek out, this is the article to do it. The Georgetown Journal of Law and Public Policy, an article by yours truly. Okay, folks. Big win in the Commonwealth of Pennsylvania. The anti-gunners try to nibble away anywhere they can. Nibble away your right to keep and bear arms. They pulled such a stunt, tried to at least, in Pennsylvania. Under Pennsylvania state law, Pennsylvania has what's known as a preemption statute. So if there's a city with an anti-gun law, city of, let's say, Philadelphia, city of Pittsburgh, those laws are preempted, which means they're stopped dead in their tracks by a state-wide preemption statute. This says to the extent there's a local law that contravenes or contradicts or somehow touches fingers with guns, guess what? It's no go, not allowed. Only the state itself can enact gun-related laws at a statewide level. Well, there was a lawsuit brought, I'm sure with lots and lots of funding by the anti-gun movement, by the city of Philadelphia, trying to advance a series of creative, novel ways to get around this preemption statute. This is the gist of what they argued. The court wrote that gun violence is taking lives and destroying families in all parts of the Commonwealth. Appellants in this case do not believe that our state government has done or is doing enough to curtail it. They believe local governments should be permitted to pass and enforce certain local firearms ordinances that appellants, that's the anti-gun movement by the way, contend will address and reduce gun violence in their communities. These provisions, generally speaking, prohibit local governments from enacting or enforcing ordinances that regulate the ownership, transportation, possession, or transfer of firearms. The appellants, sort of the anti-gun movement basically, refer to these provisions as firearms preemption laws, or FPLs. So what the city of Philadelphia basically argued was that the state of Pennsylvania was not enacting enough gun control laws, and they were doing too much to respect the right to keep and bear arms in the state constitution, that they needed to do more. And by not doing more, it violated 3 different provisions of law. This is really what the city of Philadelphia argued next. Appellants also assert that they have a collective right to protect themselves from gun violence by means of local regulation, encompassed within the right to defend life and liberty under Article 1, Section 1 of the Pennsylvania Constitution, which appellees, that would be the state, are infringing through the firearms preemption laws by preventing by preventing the cities and the localities from exercising that right to protect themselves. So that's quite interesting. So basically the city of Philadelphia is saying that the state's not passing enough gun control laws to protect people, and that somehow means that the cities should be able to step up and enact laws and override these state preemption positions. Now what's quite interesting though, and this is something that we can use I think in other litigations, is the Pennsylvania Supreme Court in this case of Crawford versus Commonwealth of Pennsylvania went on to say and reminded everybody what we talk about on this channel, that the government, that the police have no affirmative duty to protect you or to protect me from the third-party acts of criminals. This is what the court says about the fact that it's true. There is no duty on the part of government to protect us from criminal conduct or criminal attacks. The court writes, quote, It is well settled that under federal due process principles, a state, which means the government, has no affirmative obligation to protect its citizens from private acts of violence. It goes on to quote at length the United States Supreme Court in the DeShaney case that specifically points out that consistent with these various principles of the Due Process Clause, our cases, the Supreme Court cases, have recognized that the Due Process Clauses generally confer no affirmative right to governmental aid, even where such aid may be necessary to secure life, liberty, or property. So as you can see where this is going, basically, of course, the Pennsylvania Supreme Court is saying, look, the state at the end of the day gets the say because the local governments are really just arms of the state government, and the state government has the final say. So to the extent that the state of Pennsylvania wants the city of Philadelphia or the city of Pittsburgh to do something they don't want to do, the cities, as a general matter, don't have a choice by virtue of how these states are set up as a general matter. And as a result of that, the Pennsylvania Supreme Court said to these lawsuits trying to get around the firearms preemption statutes by Pennsylvania that it's simply not allowed. Here's what the court wrote in rejecting these arguments against state preemption, which as a gun owner, you want state preemption. As a reminder, why is that? Because if you don't have state preemption, it means if you go to conceal carry your gun around, let's say, the state of Pennsylvania, and you have this patchwork system of laws where in Philadelphia you can't carry it all, in Pittsburgh you can carry it on your left hip, but in another city you can carry it on your right hip, and there are all these differing laws and rules. There's no way for you to travel around the state lawfully possessing a firearm because there's no way for you to know all these laws. And that's why you have these preemption statutes so that everyone in a state basically knows the rules of the road when it comes to carrying firearms. It'd be like, think of it this way. It'd be like if you had stop signs in some of the states, or red signs are stop signs in half of the state, and then stop signs are painted blue in the other half of the state, and you would be confused in these kind of patchwork systems, and they don't want that when it comes to firearms regulation. That's why Pennsylvania, as well as many other states, don't have these preemption statutes. Now, what the anti-gunners want as a practical matter is they want to make your life a living hell if you're a gun owner. You know this. I know this. I wrote about this in my book in detail. And first they came for the gun owners. And the anti-gun movement hates state preemption laws because they want to be able to screw around with gun owners and have you cross a city line into the city of Philadelphia, and next thing you know, you're going to wake up as a felon because what you're allowed to do in 99% of the state of Pennsylvania, let's say, if you go into that one city, that one town, that one village, the one, Squirrel Hill outside Pittsburgh, whatever it is, and you violate that one gun law, you get to go to prison. That's what the anti-gunners want. They want it to be so confusing that no one is willing to carry a gun because it's too hard to figure out what to do. And that's why these state preemption laws are so successful and so helpful to the Second Amendment movement. And this is what the state of Pennsylvania said, essentially saying that these legal challenges are no good under law and they are to be dismissed. Here's what they write in the opinion. The court writes, quote, "The accounts of gun violence set forth in the petition, like all other instances of gun violence, are undeniably tragic. There is also no doubt that a serious problem exists in this Commonwealth relative to gun violence and its impacts on its citizenry. While certain municipalities and residents thereof may believe, even justifiably, that our state government is not doing enough to remedy this problem, and that a particular local regulations are needed to do so, but are preempted by the firearm preemption laws. We emphasize that the adequacy of the legislation to cope with the problem and the wisdom or the lack thereof on the part of the legislature in framing the legislation is not for us, the courts obviously, to determine. Such questions are solely for the legislature to determine, and upon their province we must not encroach." Well, that's clearly the right answer, right? It's not up to these lawsuits brought by cities within the state of Pennsylvania to try to change the laws. Now, I just want to briefly go over the three theories. The lawsuit against the state of Pennsylvania had three reasons why they claimed they would win. The first is that there was a violation of substantive due process. This is a substantive due process right, really to live and not to be shot and to be free from gun violence. Okay, that's the first argument. But again, there is no historical tradition of a constitutional right to be free from gun violence. That doesn't exist. So that argument basically doesn't fly. And the state rejected it, or I should say the Supreme Court of Pennsylvania rejected it. The second argument is they try to create something called an exception to the rule that says that government has no duty to protect you, and they call that the state created danger rule, and they try to argue that the state of Pennsylvania had created a danger to its citizens by virtue of respecting the right to keep and bear arms, and there was a serious analysis by the Supreme Court that looked through the cases and said, this is really an exceptional rule, it doesn't apply here, we've never really embraced it, so that also is a no-go zone when it comes to this lawsuit trying to knock out state preemption laws there in Pennsylvania. And the last kind of theory advanced by the anti-gun movement in this case of Crawford versus Commonwealth of Pennsylvania is whether the state improperly interfered with the public health responsibilities of these cities such as Philadelphia. They argue that there was sort of these delegations that were made by the state of Pennsylvania down to the city of Pittsburgh, down to the city of Philadelphia. This case dealt with Philadelphia specifically, but you can see it also applying to a place like Pittsburgh, the other big city in the state of Pennsylvania. And basically the Supreme Court says, nope. At the end of the day, these cities are creatures of the state itself, meaning the state of Pennsylvania creates these cities, and to the extent the state wants to take power or authority away from those cities and bring it back to itself or vice versa, that is entirely up to the state. Now, there was discussion of a couple of different concepts, something known as home rule, which says that we're going to let cities govern themselves. But even the notion of home rule, which again is the concept that a city or a village or a town can get to set their own rules, there are exceptions to that, and home rule only exists to the extent that state law allows for it. And here the state law says that no, you're not allowed to engage in gun control efforts because that would violate the state firearms preemption laws. So that means that home rule is not going to trump the specific provision dealing with no gun control laws at the local level. So there you have it, folks. Hope you check out the opinion down below in Crawford versus Commonwealth. I'll put a link to it in the description of this video. Big decision by the state Supreme Court of the Commonwealth of Pennsylvania. A very interesting decision, very well reasoned. Of course, just points out that gun violence is generated by these third-party criminals over whom the government has no control, which is clearly correct. But it's good to see that in an opinion by a state Supreme Court. So anyway, there you have it. Make sure you follow me on X. I have almost 20,000 followers on X at 4boxesdowner. A lot more information going out about the Second Amendment and other issues on X at 4boxesdowner. Don't forget to like this video and to subscribe. We're trying to get to 200,000 subscribers. We're working hard to get up there and improve our numbers, and we're trying hard to do that. And we look forward to seeing you all again here at the 4 Boxes Diner.
Orders up. Table 2A.